So you're getting a divorce. The big question is how do you go about getting a divorce, and what does it take to obtain one? When parties get married, it's like a contract. The parties agree to do certain things during their marriage. And when they get a divorce, this contract gets ripped up. And decisions have to be made as to what's going to happen with children, if they have any children, what's going to happen with their property, and what's going to happen with their debt. We have addressed those issues in other videos which we have posted. The purpose of this video is to talk about actually the mechanics of how a divorce gets put together. The very first step is, after consulting with an attorney, is to determine what you're going to initially ask for in your divorce as it pertains to your children, your property, debt, those things that you might feel that you are entitled to or should be able to receive as part of your divorce. With that determination has been made, a petition for divorce is prepared and it's filed at court. If we are dealing with minor children and the issue of custody and child support, maybe occupation of a marital residence is an issue, quite often the attorney would file a motion for temporary orders at the same time that the petition for divorce is filed. The purposes of motions for temporary orders is to try and get the parties before the court quicker than it would be through the normal course of divorce. The court then makes temporary orders, which governs the parties during the time that their divorce is pending. It might award a house to a particular parent. It can determine what the custody arrangement is going to be between the parents, as well as parenting time of the parents during the pendency of the divorce. It can also calculate what the child support is going to be, who's going to pay what debt, those types of issues. Once that paperwork is filed, it stays there for a couple of days while the court contacts your attorney to determine what date is available to come in on those temporary hearings. Once that date is obtained, your attorney then will prepare the petition and the motion for temporary orders along with its accompanying affidavit and arrange those papers to be served on the other spouse. Those papers are generally served through a process server. There are times where a spouse might voluntarily come into the attorney's office to pick up those papers and sign a document, what is called an appearance waiver, or at least an appearance in accepting that paperwork. If the other party has been served with a petition for divorce via what is called a 20-day summons, that individual then, if they are contesting anything which was asked for in the divorce, has 20 days to file a written answer with the court and to send a copy of that answer to your attorney. At that point, there is a legitimate dispute, and the parties then are going to have to decide how to go forward with their case. The most frequent step after receiving that and after financial information has been exchanged is for the parties to participate in mediation. Mediation is a requirement in Utah, and it must be done in order for the parties to continue forward with their divorce. Mediation is where the parties with their attorneys will meet with a third person who is known or called as a mediator. That mediator is not a decision maker, but he helps the parties facilitate or to try to find a way to help resolve their differences, including child custody, child support, property, debt distribution, all of those issues that are relating to a divorce. If there is an agreement at the end of that mediation, either one of the attorneys or the mediator will type up that agreement. The parties will sign it before leaving. And once that agreement is signed, it is legal and binding upon the parties, and in essence the divorce is basically over except for one of the attorneys completing the remainder of the paperwork, such as the findings of fact and the decree of divorce, which finalizes the marriage and terminates it. If there is not success at mediation, then the courts and the parties are going to have to determine what are the issues. If custody is an issue, more than likely a custody evaluator will be appointed in order to assess the best interest of the child or children and what should be the parenting time. After that has been completed, There is quite often a settlement conference with the evaluator and usually a mediation afterwards to then give the parties one last chance to try and resolve their differences. If so, again, it's the same procedure as the mediated agreement. Something is put on the record, and then paperwork follows it to finalize a divorce. If there's still no agreement, then the parties go to trial. In order to finish a divorce in Utah, it takes at least 90 days. Our legislature says that there must be a waiting period of 90 days from the date of filing the divorce until it can become final. Many divorces get resolved within that time period because they've either agreed beforehand or they've been able to get into mediation quickly to resolve their differences. There's also an issue that the parties have to attend what is called a divorce education class if they have minor children. It's a mandatory class that they have to attend, and their divorce cannot be finalized until each of the parties has provided proof that they have attended that divorce education class as it relates to the minor children. Again, divorce can be a complicated mess. It's a situation and it's an issue that should not be taken lightly, and it really should be considered only after consulting with an attorney who can give you proper legal advice. My name is Kevin Richards. I'm a practicing divorce attorney for over 25 years, handling hundreds of cases for people of northern Utah. You can read more about us by going to our website, richardsgodfrey.com. Thank you.